What is deferred prosecution for a DUI in Seattle or Washington State? Well, my name is Attorney Lance Fryrear, and I'm the owner of the law offices of Lance Fryrear. We're a criminal defense firm located in Linwood, Washington, that have been defending people charged with DUI for more than 20 years. And oftentimes we get the question, what is deferred prosecution? I've heard of it about a DUI, and should I do it? Well, I can't tell you what you should do because this video is not legal advice. I can tell you what deferred prosecution is and what are some of the benefits and some of the pitfalls of deferred prosecution. So, for most misdemeanor crimes, you're allowed to petition the court to defer prosecution. Although the most common crime we think of about doing a deferred prosecution for is DUI, driving under the influence of alcohol. And deferred prosecution is a statute, basically, that says that once in a lifetime in Washington State, you can go get an alcohol and drug evaluation from a state certified provider. And if the evaluation makes a finding that you're either alcoholic or you have mental health issues or drug problems that make it likely that you will reoffend without treatment, and they also find that you're amenable to treatment, you're able to do it, and that treatment's likely to be successful. If they find all those things, then you and your attorney can petition the court to enter a deferred prosecution program. And so the typical deferred prosecution program in Washington State is a 2-year alcohol and drug treatment program. It's typically outpatient and consists of doing group treatment along with some individual treatment sessions. The way I like to think about it is 3 group sessions a week for 2 months, 1 group session a week for 6 months, then 1 group session a month for the remaining 16 months. And it varies a little bit because it's basically how many hours you do, but that's how I like to think of it. And think of a group session as somewhere around 3 hours. Additionally, during the 2 years of treatment, you have to do 2 self-help meetings a week on top of that group treatment. That's AA, Alcoholics Anonymous, or NA, Narcotics Anonymous, those type of things. You have to prove 2 of those a week as well because we're trying to maintain sobriety. Some courts will require you to do additional self-help meetings for another 3 years on top of the 2 years of treatment. And so talk to your attorney if that's likely or not. Certain courts routinely do that. Certain courts routinely do not do that. So deferred prosecution says, yes, I agree I'm guilty of the offense, but I'm not going to plead guilty. I want to try to do deferred prosecution to eventually get the case dismissed if I do successfully 2 years of treatment and have no new crimes for a period of 5 years. So that sounds great. Why don't I just do that every time? Well, you can only do it once. And so a first offense, the penalties of DUI aren't so severe, we would typically recommend it. On a second or future offense, then it's something we look at more closely. So what happens if I mess up? What if I drink during the period of deferred prosecution? Because, they're going to be taking UAs and treatment the whole time. Well, if you drink, the court will set a review hearing and the prosecutor might ask to revoke your deferred prosecution. You'll want an attorney to argue against it. But if your deferred prosecution is revoked, you're found guilty of the DUI, just like you pled guilty. And then you get penalized, you have to go to jail and all that stuff. And you still have to do all the treatment. So don't drink or use drugs during the deferred prosecution. If you do, get an attorney. Okay? What if I get a new crime during deferred prosecution? Well, if you get a new DUI, you're probably getting your deferred prosecution revoked. You're going to get convicted. If you get something unrelated, a theft charge, something like that, maybe an attorney has an ability to argue against revocation. Certain things require revocation, certain things do not. So are there any other consequences? What else happens? My case gets dismissed in a deferred prosecution. Is there anything else that applies? Well, if you enter deferred prosecution, the Department of Licensing is for ignition interlock purposes, typically thinks of it as a conviction. It's not a conviction, but they're going to trigger an interlock requirement, and the length of the interlock will vary based upon how many offenses you've had and how many prior interlock restrictions you've had. So talk to your attorney. It could be a 1-year requirement, could be 5-year, could be 10-year. So that's something that can be triggered. Also, there's still costs and probation involved. While you're not getting fined because you're not convicted, you do have to pay the cost of probation, and you often have to see a probation person who works for the court. And that could be thousands of dollars of costs. So what are the advantages? Well, the deferred prosecution can beat the Department of Licensing suspension if it's not a refusal case. And of course, successfully completing deferred prosecution will keep you from being convicted and keep you out of jail on this charge. You still may have probation to worry about in another charge. If it's a second DUI, you might have violated probation on the first charge, where you need to worry about a probation violation there. But on the new charge, the deferred, if you successfully complete it, you're not going to jail. You're not getting convicted. So I hope that helps explain what deferred prosecution is and isn't. If you have questions or you need defense help, you can give us a call. Again, my name is Lance Fryrear. I'm the owner of the law offices of Lance Fryrear. We've been defending people charged with DUI and other crimes for more than 20 years. Give us a call. We'll do what we can to help. We'll be there for you. Thank you.